Welcome to CharityVillage Connects. I'm Mary Barrell. A recent TELUS Health Mental Health Index indicates that employees experiencing workplace conflict lose up to 55 days in productivity per year. The impacts of conflict at work are clear: lost productivity, but also stress and diminished mental health for the staff who experience it. In this episode, we explore the contributing factors, including power dynamics, racism, and microaggressions, and mounting workloads. We'll outline an organization's legal requirements to take action and leave you with some practical solutions and strategies. Joining us to discuss these important issues is Jackie Laviolette. Jackie is a partner at Mathews, Dinsdale Clark LLP. Jackie has supported employers in all areas of workplace law for over 2 decades. She represents provincially and federally regulated employers in both the public and private sectors and has extensive experience assisting employers on day-to-day matters, including workplace conflict. In addition, Jackie is trained in trauma-informed investigations and is frequently retained to conduct independent workplace investigations into allegations of workplace harassment, discrimination, or other employee complaints. Welcome to the podcast, Jackie.
Thank you so much. I'm really happy to be here.
Well, what does the law tell us about how seriously organizations need to take workplace conflict?
Yeah, and so when I think about, what a legal obligation is, I think particularly in this area of workplace harassment and discrimination and complaints, I think we have to go back and look at where some of the legislation came from. And for individuals, particularly in Ontario, there was the OC Transpo fatalities back in 1999. And coming out of that, that was a very unfortunate, horrific incident where workplace conflict led to, unfortunately, the fatalities of a number of employees as well as 2 people being injured. Coming out of that, I think politicians as well as just generally the public said, I think there's a protection mechanism that needs to be put in place. And what came out of that is, ensuring that people have a safe and healthy work environment to come to is kind of a foundation within the Occupational Health and Safety Code. So when you think of that when you think of that obligation, you think you have that duty to protect from the hazard of workplace conflict. And so in doing that, when things are brought to your attention, that's where that employer has to look and really illustrate its due diligence when a complaint comes forward. What did you do about it? How did you action it? And how did you protect your employees from what I would say is the hazard of an unsafe work environment, whether it's through, conflict, verbal conflict, physical conflict, or some other type of conflict? What actions did you take?
Well, from your perspective and experience, what are some of the signs that workplace conflict crossed a line into a situation that requires legal action?
Yeah, and so, as we know, there's a spectrum of what would fall in workplace conflict. I think when you're looking at, threats of violence are definitely something that an employer wants to be concerned about. You're looking at physical aggression, or another sign for me is really an escalation in behavior. You're seeing the signs that the conflict is not de-escalating and rather it is escalating in some way, shape, or form, whether it's in frequency, whether it's in the type of language or the type of conduct that you're seeing in the workplace. Those would definitely be signs to me that you're going to want to be doing something more than just taking in the information and considering that people may be able to figure this out themselves.
And how do the courts generally distinguish between personality conflicts or minor sort of disagreements and more serious forms of conflict, such as harassment or bullying?
Yeah. I think it's a great question in terms of the fact that everybody has personality conflicts, and anybody who's in a family knows that there can be personality conflicts, and when does it go over the line? I think what you need to keep in mind as an organization is that anything related to harassment has a definition at law. You're looking at, conduct that can humiliate or cause physical injury or psychological injury. But in looking at that definition, you're looking at not only the subjective component, how do I feel when it happens to you. But ultimately, the law looks at it and says, objectively, has it crossed that line? Would a reasonable person also consider it to be meeting that definition? And so that two combined is really where the courts start to determine whether it crosses that line, as opposed to, everybody comes to the workplace with their own personalities, and everybody also comes with their own lived experience. So maybe more, I would say, have more sensitivities or have more triggers than, say, another individual. And so when you're looking at it from a legal perspective of whether it meets the definition of harassment in the workplace, you're really looking at that subjective piece as well as that objective piece in the context of how it's occurring. And that's how the courts, I believe, make that distinction between the two, personality conflict as opposed to moving towards harassment.
And for an organization who does not take legal action, given these circumstances, what are some of the risks and liabilities?
Yeah, so I think you started the podcast by mentioning that, there's the increase in mental health issues, there's the low engagement, there's the, on the spectrum of low productivity. And that moves into, if you don't take this action, you can face an occupational health and safety complaint or investigation. That can be very time consuming and quite expensive. You could also face a human rights complaint. That's another avenue or arena, as well as a workers' compensation claim, right? If it's happening in the workplace and triggers an injury, then that organization can be on the hook for that as well, plus the costs of defending that, and then any potential penalties or fines that come out of that. Arguably, the worst case scenario would be encountering some sort of workplace violence that leads to long-term impacts to all of its employees. And so in terms of a cost, there is the dollars and cents of, having to hire someone like me. I would say that should be the least of your concerns in terms of having to deal with the obligations or liabilities that flow from this, and rather really the long-term impacts from a financial perspective of supporting your employees through it.
So assuming that there is a complaint or evidence that there's been conflict that may cross the line into harassment or discrimination or other sort of serious issues, what might it look like for an organization to retain the services of a lawyer? For organizations that are thinking they may need to go this route, what might they expect in the process?
Yeah, so when a complaint were to come in initially, I think that you would contact the lawyer, you would share with them, the information. Ideally, we like to say get advice early and often, because sometimes if you're just seeing conflict in the workplace and you're not quite sure what to do, that first phone call to us may be able to de-escalate the situation, or at least defend the organization against some of these larger concerns around occupational health and safety. In terms of retaining a lawyer, there'd be a conversation about who's involved, and then it can be a phone call. Potentially might be the first way that we just try to de-escalate the situation and protect your interests, or it can lead to giving the advice and moving forward with a more formal investigation, creating that report. And there is a spectrum in terms of dealing with it. Ultimately, when clients call me and they say, I just have this situation, I consider it, the situation can be having a conversation with those two individuals and being able to illustrate to a court what actions an organization did to protect itself and its workers and de-escalate the situation. Sometimes that is a conversation. And I say that's small I investigation, right? You're trying to figure out what's going on and you're trying to figure out what to do to protect your employees. Then it can move all the way into, hi, we've received a human rights complaint, right? In that case, you're looking at something more formal. You're looking at receiving the complaint and having to respond in writing, whether it's to the occupational health and safety, to workers' compensation, to human rights. And then that engages its own court process with its own rules and procedures. It's a more lengthy process. It can be very time consuming in terms of years potentially. So that's why we say early and often is usually the best advice in these cases.
Right. You try and nip it at the bud as much as you possible. Right. And we've been talking about the employer's perspective and position in this circumstance, but what about the individual staff members who might be considering taking legal action due to their experiencing harassment, violence, or bullying in the workplace? What kind of steps would that individual likely be advised to take?
Yeah, so I think if an employee is considering legal action, I mean, ideally, you always like to be informed or educated first. And I would say that any employee who is looking at that, I mean, if you have a manager and you're considering that, they do have an obligation to let you know what avenues are available to you if you feel that you're experiencing harassment or discrimination in the workplace. The second would be any of the great government websites, whether you're dealing with Human Rights Commission, whether you're dealing with workers' compensation or occupational health and safety. There's a number of amazing and incredible resources out there related to what a complaint looks like and how to deal with that, or even speaking with individuals in that sphere or who work in that area. Really, it's about informing you of the process as opposed to maybe advocating or representing you as a lawyer. Any employee would have a right, if they're not unionized, to be able to get their own lawyer. But if they are unionized, that's another option available to the employee to go and get advice and resources. And then ultimately, it is a matter of moving into a more formal process through, creating your complaint in writing and providing that into the tribunal and going forward from there.
Now, we've been talking about, I guess, the involvement of legal action and going before the tribunals that you've discussed. Can you explain some of the steps that may be available in terms of things like alternative dispute resolution, mediation, arbitration, etc.?
Yeah, and we're actually seeing quite an increase in alternative dispute resolution because I say most times by the time that the investigation is occurring, if someone comes forward with a formal complaint, usually that's a very, very difficult situation and they're in a right fight, as I call it. I want to be right and you want to be wrong. So again, that early and often is helpful in alternative dispute resolution. When we use that term, we're talking about the opportunity for the parties to come together, do more interest-based conversation, really get to the root of the issues of what's going on, as opposed to what maybe a tribunal might decide has occurred. And so when you do alternate dispute resolution, if you're with a mediation, that might require a third party. It can be a lawyer, it can be someone who's trained in mediation to come in and can really listen to the interests of the parties. And maybe sometimes the conflict does not come from what actually occurred, but there's some deep-rooted issues and an opportunity to understand how people come to that conflict as a means of resolution. So I find definitely alternative dispute resolution can be very, very helpful if both parties are willing and able to move through the right fight and move into trying to work together or workplace restoration of some type. I would say that if one party wants to be right and one party wants to be wrong, that's where I would say alternative dispute resolution tends to break down.
And what role does human rights law play in these types of workplace issues? We have an increased spotlight on diversity, equity, and inclusion. Certainly in the nonprofit sector, there's a lot more awareness than there used to be. I'm curious as to whether you're seeing an increase in cases involving people from marginalized communities, perhaps complaining of discrimination or microaggressions at work, for example.
I would say that I have seen just an increase in complaints all around, actually, coming out of COVID. I would say, I describe it as a bit more of a conflict culture and really that right fight. But, when I dig deeper into the issues, sometimes it comes from just more education and awareness that people are more familiar that rights are available to them and that they have these protections in the workplace that they may not have known. They may have just always thought that this is how people treat me, right? So first off, I think the education and awareness is leading to more complaints. Secondly, I would say that more education and awareness around not only the personality conflicts or the conflicts between two people, but recognizing that examination of the lens goes further. And what are the systems and the processes in place that may be contributing to whether it's harassment or discrimination in the workplace. So those marginalized groups are recognizing that there may be systemic discrimination at play or systemic racism at play. And I have definitely seen an increase in my practice around marginalized groups coming forward and questioning and feeling that the harassment or discrimination is stemming from some more of those systemic issues or, coming from recognition of decolonization and an Indigenous recognition in Canada.
And I wonder if you could talk a little bit or explain the sort of process that occurs when a formal investigation has to be done.
Yeah, so if a formal investigation has to be done, we've determined that we're going to give notice to the parties. So the complaint would come in, we would define what the scope would be very clearly on what the allegations are. We would give that notification to the individual or the individuals who are alleged to have undertaken the conduct. It usually involves interviews with all the parties, and that means the complainant, the person who complained, the respondent, the person who it's alleged to have done the behavior, and then any witnesses who may have firsthand information. It can include a documentary review generally. Then more formally, it involves a report that's provided, and then of course determining the outcome. In my case, in my practice, I do a lot of investigations and then I would provide the report, and it's ultimately the organization has to determine. You would get a report that says these are the allegations and they're founded, but the organization has to determine what it looks like in the workplace for this individual if there are founded allegations. What does it look like for these people to work together or not anymore, and what scale of discipline is needed in order to prevent this behavior from reoccurring?
So that could even be termination, for example.
Oh, absolutely. So when you're looking at, founded allegations of harassment and discrimination, I would say you have to take them very seriously, recognizing that on the scale, there is progressive discipline. So, when we're talking about having a conversation with someone and telling them not to do it again, that is very different than doing a formal investigation and then just telling them not to do it again. If you have founded allegations of harassment and discrimination, you really want to look at, again, what are you going to do to prevent that hazard coming back into your workplace? So is that individual continuing in the workplace or not? I would say that the courts do find that, founded allegations of harassment are considered serious by the courts because of when you look at that foundation of how these laws came into being and really preventing your worst case scenario of a fatality in the workplace, for example, related to workplace conflict. So with that in mind, I think, you really need to consider all of the circumstances related to imposing discipline, but ultimately come from the place of keeping your workers safe and creating a safe and respectful work environment and what is needed to do that.
And I wanted to wrap up by giving you an opportunity to, I guess, provide our audience of any sort of last advice that maybe we haven't touched on in our discussion that you think would be helpful to them.
I always like to say that if you're facing a conflict in the workplace, if you're particularly the organization, what you want to be doing is considering if somebody asked you, a year from now, you heard about this and what did you do? So you want to be able to answer that question, and you want to be able to answer why did you do that? And that doesn't mean that you always have to jump to a formal investigation for every single thing that comes forward. It also means that you want to be able to address things that come forward and be able to illustrate, is it a conversation and did I document that, and why was I satisfied that that would protect protect the individual in my workplace, or no, this is very serious and we've seen an escalation, so that's not going to we're not going to allow this to continue and we need to do a bit more of a formal investigation. Does it involve keeping people separate within the workplace? Might that just resolve the issue? So really coming from a place of what's required to de-escalate the situation and what's required for the organization, separate and apart from the people, to be able to illustrate to a third party, these are the actions we took. This is why we thought they were sufficient to protect our workers in the workplace. And and we can document that. I always like to say lawyers love documents like kids love Smarties. So we like to have a lot of really colorful, good Smarties to be able to present to that organization or that tribunal to be able to illustrate those actions. And if you do those things, 95% of the time the organization is going to be fine, and 5% of the time you might have to hire someone like me.
Well, Jackie, it is truly a pleasure to speak with you and hear your fascinating insights. Your perspective on workplace conflict and your practical advice is enormously important as nonprofit employers and professionals grapple with this issue. Thank you for joining us on Charity Village Connects.
Thank you very much for having me.